Don't forget to fund that trust, right? If you have a living trust, you need to make sure that it's funded properly, titled properly, etc. So what happens a lot of times is people create a living trust, but then they don't do anything about it. They don't retitle their assets, their bank accounts, investment accounts, cars, boats, home, anything like that. Well, if it's not owned by your trust, it's not controlled by your trust. There's a couple different ways to think about this. If it's not owned by your trust, or payable to your trust, or payable to another beneficiary through a transfer on death deed, TOD, or payable on death deed, payable on death, POD, then it's probably going to have to hit your will and go through the probate court. If you had a trust, then it doesn't hit your trust, or maybe it gets probated through your will and then poured over into your trust. But why have that other step if you might be able to avoid that? If you have an asset that is owned by the trust, then it's owned by the trust. If you become incapacitated, that trustee should be able to step in and manage the trust per the terms of the trust. If you pass away, the trustee should be able to step in and manage the trust per the terms of the trust. If it's not owned by the trust, but it designates the trust as a beneficiary, for example, let's say I have a account with my wife, investment, bank account, something like that, and it's a JTWROS, Joint Tenants with Right of Survivorship, in Texas. If it's set up correctly, then it goes from me to my wife, or from my wife to me. And if I named my trust as the beneficiary, then when we both pass away, then it'll go into the trust. Then the trustee would have access to be able to manage those assets, but only once the trust becomes the owner and not before. That's another way to get it to the trust, but you need to do that now, because once you pass away, you can't name something as a beneficiary because you're not alive to name it as the beneficiary. Another way to stay out of probate, just while we're on the topic, is just to name a beneficiary on said account: bank account, life insurance, investment account, retirement account. And then in that case, if I'm the owner, for example, and I say it goes to one of my children, it would go to that child. It would not go to my wife. It would not go to, barring some IRA rules or 401k retirement ERISA rules. Let's just say a bank account. If I said it goes to my kid, and it's not community property, then it goes to my kid, for example. Or if I say it goes to my wife, it goes to my wife. But then it would stay out of the trust. It would stay out of the will. So you need to make sure that if you have a trust, that you get everything titled appropriately. And you need to talk to your attorney to figure out what that titling looks like, because for each client, how you title your assets is actually different than the next person down the road. Trusts are so unique for your particular circumstances. I'm attorney Mike Massey. I've helped over 1,000 families with their estate planning in Texas. I'd love to have a conversation with you. Simply click below to learn more, or call me. We'd love to have a conversation with you. Look us up at Mike Massey Law.